Okay, so I'm just going to share my screen, and Martin, you just let me know when you want me to change the slides.
Fantastic. Thanks, Joe.
Okay, and can everyone sort of see that presentation now?
Yep, I can see it.
All right, over to you, Martin, and any questions just at the end. Thanks, guys.
Thanks very much, Joe. Well, thanks, guys. Thanks for coming and inviting me to speak today. As you can see, and as Joe's explained, I'll be discussing today the latest trends in dust-related diseases, primarily focusing on asbestos diseases. There have been a fair few cases across the last 10 to 20 years, and what I thought I might do today is really just give an overview of the more significant cases that have been handed down by the courts and tribunals across Australia, virtually all of Australia. As we all know, some states have more judgments than others, so I'll deal with those cases as they arise. And I basically cherry-picked the main cases, as I say, and it's in chronological sequence. So if anyone has any questions in relation to the relevant period that I'm discussing, feel free to ask then or message or leave it till the end, not a problem. So thanks, Joe. If you can just move to that next slide. What I've done, thanks, Joe, you'll see that there's a number of cases there that I'll discuss today, and they're all focused on the quantum aspect today. So a lot of it will be focused on what judges have awarded, and in particular, general damages for pain and suffering, and some loss of life expectancy. That's the main gist of my focus today. So without further ado, what I'll do is I'll start off with the first case off the rank, Smith and Sydney Water Corporation. So we're starting off in the very start of the 21st century. Mr. Smith was sadly diagnosed with mesothelioma. He was exposed when he was with the Metropolitan Water Sewerage and Drainage Board. He's born in 1951. He was 49 years of age at the time of judgment and had a life expectancy of 31.7 years. So the plaintiff suffered from a variety of different medical conditions prior to his condition of mesothelioma. He had polycystic renal disease in 55, trouble with that on several occasions, had kidney issues, various hemorrhages and other medical comorbidities. Having said all that, the court looked at those past medical conditions and said that damages for the mesothelioma shouldn't be reduced necessarily just because he had past medical conditions, particularly if they were stable and under control. What occurred with Mr. Smith was in March 99, he started to suffer from symptoms. He underwent medical investigations and treatment. Dr. Hart was a thoracic specialist who looked at him, and he had persistent cough and various other issues in relation to the mesothelioma, including pleural effusion. He was diagnosed by Dr. Hart, and from that point onwards, I was told that his condition is terminal. In February 2000, what occurred was that his symptoms started worsening. He had sharp pain in the chest, and that was followed rapidly by the onset of paraplegia. So there's a number of medical conditions that were arising as a result of the recent diagnosis. Doctors couldn't decompress the lesion, which was causing the symptoms, and he endured some serious pain and suffering moving forward. What occurred was that his medical investigations and treatment moving forward into the hospitals were just an absolute disaster. He was in constant pain. There were issues in relation to the care that he received, and it was just all a real unexpected problem after problem. In the end, the court found that he had enormous, obviously, physical symptoms from the mesothelioma. He also had mental distress. And the court found that it was a condition of the most serious nature, particularly given his past history in treatment, and the court awarded $200,000 for general damages. Next case, Esther and Amica. Amica, of course, is the current entity that people sue for exposure arising from James Hardie products, the entity which manufactured and supplied asbestos products across Australia for many decades. In Mr. Esther's case, the plaintiff was 67 years of age, and he sued for a variety of issues. And the Dust Diseases Tribunal, which is the forum in which he in which the previous case was brought, was a very sympathetic jurisdiction. In Mr. S's case, he sued in the Western Australian Supreme Court. And of course, as we'll see throughout my presentation, there's a variety of different factors that come into play in assessment of damages, and each jurisdiction seems to have been fairly consistent with how they've approached damages in respect of their own forums. So you'll see a difference in damages rising from one jurisdiction to another, particularly when you look at the Eastern Seaboard versus South Australia and then Western Australia in the West. So in Mr. Etz's case, they assessed his case with some detail because it was a time when the Just Diseases Tribunal had been in place for some time, about 22 years in fact, and there had been a number of judgments for people of similar age with mesothelioma, and the court looked at a variety of cases including Panizza, Edwards, Brennan, and the last case that I mentioned of Smith. And in this case, the court found that in terms of assessment of damages, there must be fair and reasonable compensation to the injuries received and to disabilities caused. In other words, the judge was saying that each case turns on its own facts, and while there are different judgments in different jurisdictions, each case has to turn on its own facts and own circumstances. And of course, there's the overriding consideration of the general ideas of fairness and moderation. So having regard to and the benefit of previous cases, this particular judge in Western Australia decided that general damages ought to be awarded and were awarded in the sum of $130,000. Next case of Nielsen. This case, again, we're going back to New South Wales and the DDT. The plaintiff was exposed to asbestos in the 50s and 60s. This case I've thrown in there to give a bit of a comparison in relation to what damages are awarded, not from necessarily malignant conditions, but benign conditions. Mr. Nielsen had asbestosis and asbestos-related pleural thickening, but also, interestingly, had a history of pleural fluid buildup. But the issue there was that they could not confirm that it was in fact related to his asbestos exposure in the past, and they could not diagnose mesothelioma. However, his impairment of the whole person was 40%, so quite significant, and he also suffered from occasional chest pain. So he did have the indicia of a condition like mesothelioma, but unfortunately didn't have sufficient evidence to prove it and discharge its burden of proof in that regard. The plaintiff, Mr. Nielsen, was 65 at the time of hearing, and the judge awarded general damages in the sum of $90,000. So quite a stark difference there. Next case of Reynolds. This is a case arising out of the South Australian jurisdiction. Mr. Reynolds sued Comcare. He was born on 20 February 1940, and at the time of judgment, he was about 65 years of age. He had enjoyed reasonably good health leading up to judgment. Unfortunately, in about November 2005, the symptoms of his condition had deteriorated. He was suffering from shortness of breath. He was diagnosed with suspected pneumonia. He underwent x-rays and radiological investigations, which revealed pleural effusion in his right lung. So he had a unilateral effusion. The doctors reviewed his notes and history of presentations and realised that there was a worsening over time. Within about 2 weeks or so, he had developed more pain and increased shortness of breath. Following further investigations, including x-rays and ultrasounds, as well as CT scans, he was referred to the Lyell McEwen Hospital and underwent a fluid drainage of the right lung on 30 November 2005. What occurred then was doctors couldn't diagnose anything in particular, so they decided to undertake further investigations. That included care under a cardiothoracic surgeon who performed a variety of procedures, and that included a video-assisted thoracotomy and talc pleurodesis, which of course is the insertion of talc in the pleural lining to prevent fluid buildups, etc. And they drained the fluid, and once that was done, they analysed the fluid and diagnosed mesothelioma. So over a relatively short period, there was quite a severe bout of symptoms. Doctors advised the plaintiff in relation to his prognosis, and there was some chemotherapy offered and administered. Unfortunately, by June 2006, there was a real substantial worsening, which led to the use of a walking frame, and there was some assistance needed from moving from bed to chair and minimal distances. By about late August, there was the use of oxygen required. And at the time of trial, the life expectancy of the plaintiff was only 10 weeks. It was very sad. The judges reviewed the situation, reviewed previous authorities, and decided that, notwithstanding the severity of symptoms, the general damages that should be awarded over the period of some 17 months of suffering should be in the order of $100,000, and that's what was awarded in the end. Case of Smart. Case of Smart is one that comes out of the New South Wales DDT. It's no surprise there's a fair few judgments that have arisen from the New South Wales jurisdiction. It's a specialist tribunal, and you'll see more cases coming through my presentation from the New South Wales tribunal. Just a quick note on Mr. Smart. Mr. Smart was a case that was determined in 2008. So we're now 8 years on since Stephen Smith's matter. Mr. Smart was 74 years at the time of hearing, 74 years of age, and exposed to asbestos dust and developed mesothelioma. The court found that in circumstances where there are similar symptoms and similar history as per previous cases, comparable awards were considered. And given the fluctuation of time, the court found that an increase of general damages ought to be made, and ultimately a verdict was given in the sum of $200,000 for general damages. So this is where we see the damages rising significantly. In the same year, Mr. Backer, Mr. Backer's case was heard by the tribunal. Mr. Backer was an interesting case because he was a lagger. He had heavy exposure to asbestos from insulation materials that contain asbestos. The allegations were that he was exposed over 20 years from 1961 to 1981, and he was diagnosed with severe asbestos-related pleural disease. Following his diagnosis, he suffered 2 strokes, and the pleural effusions that he then suffered were actually not cardiac related. The court had a very difficult time, however, distinguishing between the different, or should I say, disentangling the different symptoms and conditions. He was suffering from a fair few different conditions, and ultimately the court identified that some asbestos disease was certainly causing symptoms, but then again, it was too difficult to prove other conditions causing symptoms, including the pleural effusions that were subsequent to the initial diagnosis. Mr. Backer was 73 years of age at the time of hearing, and the court found that an appropriate award for general damages was $115,000. So again, it's an uplift of the previous cases that we saw for benign disease, and we're looking at differences about $30,000, $40,000 for similar sort of ages with similar sort of severity of suffering over a couple of years. With Mr. Mooney was a case again out of the DDT. Mr. Mooney was exposed to asbestos dust and fibre. He worked as a labourer in the 1960s and developed mesothelioma from exposure to asbestos products. Mr. Mooney's case I've noted because he suffered from quite serious symptoms across not 12 months or 18 months, which is typical median life expectancy for mesothelioma, but he suffered for 4.5 years. So an enormous level of suffering over a prolonged period. And he was only, respectively speaking, 59 years of age at that time, where most cases for mesothelioma and, in fact, for dust disease in that decade and previous decades often saw the plaintiffs being older. And Mr. Mooney's case, the judge reviewed those circumstances and took the age into account as well as the duration of symptoms and awarded general damages for his asbestos-related disease in the sum of $290,000. So this is where we see a really significant lift in the damages across that 9-year period. The next case of Parkinson, I've added in here just recently, just to give an authority. It might not be on the slides there, Joe, this one, but I'll just mention it anyway. It's Leonard Parkinson's against Lendlease Securities and Investments. It's a case from the ACT 2010, 49. And I've mentioned this case because there aren't a whole lot of cases that have been determined and published out of the ACT. In this case, the plaintiff was 72 at the time of 12 February 2010, so 72 years of age just before the time of judgment. Quite a tragic and distressing case. He developed mesothelioma due to loose asbestos fibres whilst employed by the defendant, working on a particular mall in Canberra Centre. The plaintiff didn't really have any knowledge of his exposure until about 2008 when he was in fact diagnosed. So it came as a big shock. He'd undergone various treatments, but was told there's just absolutely no cure and he was a terminal case. The parties agreed that Mr. Parkinson's life expectancy as a result of his condition of mesothelioma fell within the median range of 18 months. And they agreed on a variety of other issues that narrowed the issues in dispute. And out of the ACT, the judge awarded general damages of $300,000, which is now, as you'd appreciate, sort of commensurate with those cases that we've described in the DDT. Now, the final case for this slide is Lowe's and Namica, a case coming out of the Western Australian Supreme Court in 2011. The plaintiff was born in 1969, and once again, another example of a plaintiff that was quite young. He was 41 or 42, it's not clear from the judgment, but certainly in his early 40s at the time the judgment was delivered. He suffered from a different, well, not a different form, but a more unusual form or uncommon form of mesothelioma. Typically, those that practice in the area would see a lot of mesothelioma diagnosed in the chest cavity, and in this particular case, in Mr. Lowe's case, it was a peritoneal mesothelioma, which is, of course, is the mesothelioma that affects the peritoneum and around the stomach, abdomen area. And what occurred was that Mr. Lowe's was exposed whilst on the railways. He had enormous exposure. It was really just about the quantum in his case. The court acknowledged that Mr. Lowe's was quite young at the time that he contracted mesothelioma, having regard to the long latency period of the disease. There was notation made by the court in relation to the many investigative procedures that were undertaken by Mr. Lowe's, and they noted that as being relevant in terms of assessment of damages. One of the first matters expressly acknowledged by the court, which was good to see, was that the fact that as time has moved on, so have damages, and there was different ranges provided for what assessment should be made. There was a submission made that 150 to 200 should be the range, and the submissions included reference to various cases for mesothelioma, both in Western Australia and other jurisdictions, which included Esther, McGillivray, Missy Ellis, which is a famous case on lung cancer, and Hanel. In the end, after all the submissions made, including counsel for the plaintiff submitting that an appropriate, fair and assessment for general damages was $500,000, the court disagreed with that assessment. Notwithstanding substantial awards made in other jurisdictions, including the DDT, and the court decided that an appropriate award would be $250,000. In that case, given that it was peritoneal mesothelioma, there was consideration given to some other procedures that ordinarily wouldn't be necessarily applicable in a pleural mesothelioma case, including the evidence given by Professor Fox about the availability and the outcomes of peritonectomy, which were performed on the plaintiff. In the next case, on the next slide, Joe, if you could just turn to the next one, thank you. In the next slide, we'll talk about the matter of King. This was an interesting case decided in 2011. It was first decided by the Supreme Court of Victoria, and it was a very large verdict for the plaintiff. Mr. King had an interesting history of exposure. He only was exposed to asbestos for a period of 6 hours over 6 hours over 3 days in 1972 whilst visiting the Hardy's factory and as a result of that exposure, developed mesothelioma. There was some dispute about exposure, etc., but ultimately the plaintiff succeeded and an assessment of damages was made before a jury. Mr. King, relevantly, was again quite relatively young. He was 62 at the time, and the jury had been briefed on appropriate ways in which to award damages and assess the matter. And ultimately, the jury found that after deliberation, the appropriate award should be $730,000 for general damages, which was a record at that stage. When that verdict was handed down, Amica didn't really enjoy that, and they appealed to the Court of Appeal, and ultimately the appeal court thankfully was not persuaded that the sum awarded was what was described as being beyond what a reasonable jury, properly instructed and with all due attention to the evidence, could arrive at. So the appeal was dismissed, and the award of damages upheld, which was great news for the plaintiff. In the next slide, next case, Hamilton BHP Limited, 2012, South Australia. This was a case involving Mr. Hamilton, who was born on 14 May 1940. He tragically died from mesothelioma on the 14th of August 2007. He was aged 67 at time of judgment, so again, relatively young. A lot of the people that come through with mesothelioma or even severe asbestos-related disease that's benign in nature, often in the 70s or 80s and sometimes into the 90s. So 67 is relatively young, particularly given that that's now considered the ordinary retirement age. And Mr. Hamilton suffered a number of medical conditions. So I've listed this case because it does show that you can get awarded substantial damages in a case for mesothelioma, even where there are a number of medical conditions that have been diagnosed and suffered from that are unrelated to the alleged exposure. In this instance, Mr. Hamilton had severe face injuries in 1965 from a car accident. He had bowel cancer in 1992 with resection. He developed diabetes and blood pressure about the same time as the malignancy in 92. In 2005, he had cancer of the bowel representing and had the large bowel removed. And then in October 2006 is when he started to suffer from the symptoms relating to mesothelioma. In this case of Mr. Hamilton, his duration of suffering was on the shorter end of the scale because, as I mentioned, he died tragically from mesothelioma on 14 August 2007 and was diagnosed in February 2007. So about 6 months of suffering, and general damages were assessed at $115,000. That was felt to be somewhat... So was that a question, sorry?
Let me just finish this, if you don't mind.
Oh, yep. Just with Mr. Hamilton, the general damages were assessed at 115, but as I said, that was not the end of the road because that was felt to be a little low, notwithstanding the previous medical conditions, and the appeal was heard, and that was felt to be manifestly inadequate, and thankfully the Court of Appeal provided a new award of general damages at the sum of $190,000. So a significant uplift from the 115, and respectively more commensurate with the cases in South Australia in those circumstances. In the next case of Gay and Resi Corporation, this is a case coming out of South Australia. Once again, this is 2013. This case you'll see is similar in terms of quantum. Plaintiff was born in 21 August 1928 and was diagnosed with mesothelioma. The plaintiff was very much in good health up until her diagnosis, didn't have any ongoing medical problems and led a fairly active lifestyle. She experienced tiredness and pain in the chest, and by about April 2010, so about 12 to 18 months onwards from the initial initial onset of symptoms, she had significantly deteriorated, and suddenly she required fluid extraction from her pleura, suffered from increased chest pain, and ultimately experienced the typical symptoms of mesothelioma. The court had a look at this case and considered the unrelated conditions and mentioned that the comorbidities were found to independently compromise the plaintiff's quality of life, which had the potential to lead to his death before the mesothelioma. And having said that, where there was some ability for unrelated conditions to be life-threatening, the court assessed general damages at $175,000. In this next case of Alcan Gove and Zabik, this one went all the way to the High Court. For those that practice in the area, be familiar with this case of Zabik. This was very much a case which involved some technical issues in relation to exposure to asbestos and when the damage ensues. And as I say, it travelled from Northern Territory Trial Division to the Court of Appeal and then to the High Court. Fortunately, just to finish off on the point, the court found that the long line of authority in relation to how damage is considered should be left unchanged. But in this case, the court did mention that there was a substantial sum awarded for damages. Unfortunately, the damages were really very much assessed and agreed upon without the court's intervention, and they were $425,000. So it's difficult to say what award for general damages was made without any particular specific reference to the heads of damage, but certainly not an insignificant sum if the ordinary type of heads of damages were claimed and considered. I think that's quite a substantial sum in that context. The next case I've got on my list here is Mr. Zanetic. Mr. Zanetic was born in Croatia in 29 May 1939, and he was 78 years at the time of judgment. He was exposed as a carpenter after arriving in Australia in 1962. Spent a lot of time in Sydney in the Padstow area of New South Wales building fibre cottages, and that was his main source of exposure to asbestos. Mr. Zanetic had exposure to a wide variety of Amica or James Hardie products, and consequently, of course, Amica was sued. In this case, I've mentioned it because it does represent an increase in general damages, but in circumstances where Mr. Zanetic actually had not insignificant medical conditions prior to his diagnosis with mesothelioma. For example, 18 years prior to diagnosis with meso, Mr. Zanetic suffered from chronic lymphocytic leukemia, and that was present since the late 1990s. He was treated by hematologists and underwent various investigations and treatment, but ultimately the disease did compromise his immune system and provided him with various troubles in that regard. In relation to the mesothelioma, the other comorbidities, chronic lymphocytic leukemia, did have a role to play because that affected his ability to fight off chest infections and the like. And he had pains in his chest as early as 2009. Noting that this case was 2017, it represents a very long period of suffering. Mr. Zanetic had shortness of breath, chest pain that occurred frequently and regularly from 2011 to 2015 when they became extremely severe. And when diagnosed with mesothelioma, he was taking 8 Panadeine 4 tablets per day. He underwent chemotherapy and suffered from numerous pleural effusions. By 2016, by Christmas 2016, he had lost approximately 10 kilos in weight over a 3-week period. He was having night sweats and virtually no appetite. So he was in a great world of pain by that stage. At the time of judgment, the parties agreed on the life expectancy of 8 weeks. His Honour Judge Russell was the judge that determined that case, and in circumstances of the long-standing suffering, notwithstanding the chronic lymphocytic leukemia and other comorbidities, the general damages made was the award for general damages was made in the amount of $350,000. So quite a quite a substantial sum there. And that award is one which has been sort of kept as almost a minimum moving forward across the years since 2017. Next case of DIB, you'll see there on the list. Again, this is one that has arisen from the New South Wales jurisdiction, from the DDT. Mr. DIB against Amica. It was decided on the 22nd of August 2017. In this case, the plaintiff brought proceedings against Amica for exposure from 1975 to 1984 as a plumber. He was exposed to various Gentati products in that period, and he suffered from a left-sided malignant pleural mesothelioma. Once again, this case was decided in 2017 in August. His symptoms appeared in about late 2015. That was the first evidence when symptoms seemed to have arisen. Mr. Dib was born on the 15th of March 1940 and 77 at the time of judgment, having retired in 2011 at the age of 73. What occurred was that there was no issue in relation to liability, and it was really just an assessment made by the court. Professor French, revealed again and gave evidence that the median survival following diagnosis was that 18-month period, although he did mention that specifically with this condition, which Mr. Dibb suffered from, which was epithelioid subtype of mesothelioma, gave a slightly better prognosis. In terms of the survival, however, it was difficult to provide accurate comments about how much better prognosis the plaintiff would have in these circumstances, and there was difficulty because a number of other experienced experts that do give evidence in the tribunal, including Professor Breslin and Dr. David Freiberg, gave evidence, and it was tricky to provide precise calculations of prognosis. What happened was there was a fairly significant smoking history, and the court found the plaintiff smoked for about 60 years at an average of about 20 cigarettes per day, and there was a whole issue in relation to the effect of that smoking on lung-related disease that was not associated with asbestos exposure. The court considered the life expectancy at some length and said that a 77-year-old man without any long-standing smoking history on the ordinary life tables would be 11.22 years. And there were some issues raised and arguments made by the plaintiff's advocate that that should be adopted due to it being in the life tables. Unfortunately, with the issues raised in relation to smoking and the experts giving evidence about that effect on reduction in life expectancy, together with a study that was published in BMC Medicine in 2015 relating to tobacco smoking and cause of mortality in a large Australian cohort study, the court found that a lesser life expectancy should be adopted, reduced it by 2 years and gave a 9-year life expectancy that had been lost. But notwithstanding the smoking component being a significant consideration, the life expectancy, general damages were still awarded in the sum of $350,000. Next case, Mr. Talaferro. Mr. Talaferro was a case that was heard in the DDT once again. This was heard just before Christmas in December 2017. His Honour Judge Russell was the judge that determined this case as well. Unfortunately, in Mr. Talaferro's case, the condition of mesothelioma was tragically attacking him to such a degree that he was unable to give evidence at the trial, and he had deteriorated too quickly. The proceedings were amended to include an estate action, and ultimately the hearing was confined to 2 issues. Ultimately, one was the exposure to Hardy's products and then damages, and as with many of these cases, it was proven that the exposure occurred to the defendant's products, and it became just an assessment of damages. The court noted that the plaintiff was born in the UK on 15 May 1931 and died at the age of 86 in 2017. The plaintiff was retired in 96, and at that stage the court held that or accepted that he was very, very healthy for his age, and he had led an active retirement travelling twice a year overseas. The court also found that the plaintiff walked his dogs daily along the cliff tops of Maroubra. He held hobbies and he was a very, very active and energetic man. Evidence was given in relation to how energetic and how social this person, Mr. Talaferro, was, and he was described as being the life of the party in social settings and extremely active. In those circumstances, notwithstanding his age of 86, the court found that an appropriate level of general damages ought to be $360,000. So a slight uplift on the previous few cases that we've just discussed. The last case on my slide here is Mr. Lavis Namaka. Lavis Namaka was decided in 2018, 24th of April 2018, before Judge Scotting, relatively new judge on the tribunal at that stage. The plaintiff was gravely ill when he gave evidence at his home, actually, on the 19th of April 2018. The plaintiff was born on 5 May 41, developed mesothelioma in October 2017. Once again, very fit, active and healthy man, never smoked, performed all the maintenance in his home, gardening, pool maintenance, mowing the lawns, etc., very active, very full of life. By about October 2017, symptoms came on, and within about 3 to 4 weeks, there was a biopsy done, and that revealed the mesothelioma. Within 3 months, there was enormous onset of pain for Mr. Lavis, and what occurred was that he was administered the usual pain relief medication. His symptoms progressively worsened, and at the time of judgment, he was 76 years and 11 months old. The court noted that the plaintiff was very close with his family, very tightly knit, and he never had any problems active at that age. The court held that an appropriate award there, the general damages, should be $370,000. So again, a slight increase on the previous case. So that's that slide done. Joe, if we can move to the next slide, please. Thank you. Mr. Roberts, once again, a case that has been was heard by the DDT in New South Wales. This case was decided by His Honour Judge Russell. In this case, Mr. Roberts was born on 4 January 1931. He was in fact 87 years old at the time of judgment. It was a case for mesothelioma. The court noted some issues in relation to his medical history. Mr. Roberts had back pain in early 2017. The symptoms were probably lasting about 12 months leading up to judgment. He was one that was diagnosed on pleural biopsy. By the time he reached judgment, he was in excruciating pain, was described as being in excruciating pain. He was just coping. He had no chemotherapy, but only radiotherapy, which ultimately was no benefit, unfortunately, and was on oxygen in the days leading up to judgment. In that case, the general damages were agreed by the parties at $330,000. Next case, Mr. Webber and Comcare. Mr. Webber is this case against the Commonwealth Government. Once again, in the DDT, heard over a couple of days in December 2018 before Judge Russell. There was, interestingly, in this case, I've mentioned it because there was an interesting issue in relation to choice of law. In Mr. Webber's case, he was served in the armed forces, and he served not only in New South Wales but also Northern Territory, Queensland, and in fact Malaysia. Mr. Webber alleged exposure for his asbestos exposure in Northern Territory, New South Wales, and in circumstances where there was only one defendant sued, being Comcare, the court ultimately accepted the evidence, and it was really just an assessment of damages that was made. And given the circumstances and the allegations, with mesothelioma being an indivisible condition, the court provided 2 assessments of damages, one for the Northern Territory exposure and one for the New South Wales exposure. And in this case, it's interesting to see that the general damages for Northern Territory were $450,000, and the general damages for New South Wales exposure were $350,000. Ultimately, there was a totaling damages assessment of $1.1 million, and the judge made various relevant comments in relation to the plaintiff's prerogative to choose how the plaintiff wished to have those damages recovered, but without, of course, double dipping. Next case of LATS. Once again, this is a case that made its way all the way up to the High Court of Australia. It was a case that was a significant case for its time. It was a novel case that dealt with the pension and whether it was recoverable in circumstances where a person lost their life or had a reduced life expectancy. That into detailed technicality in that case. The case is one where
sorry to interrupt, Martin.
Plaintiff succeeded. Sorry?
I'm not sure if it's on my end, but I think there might have been a bit lag in that last bit you mentioned. Just sort of 10 seconds back, you go over again.
Oh, sure. Sorry about that. I'll just quickly run over this case of Amica and Latz again, which is the 2018 case that made its way to the High Court. I'm also conscious of time, so I'll try and keep my comments brief. This case raised a variety of issues. It was very novel and a very interesting case from a legal technical point where allegations were made that the plaintiff lost the financial benefit of the pension as a result of the shortening of life expectancy due to the conduct of a tortfeasor. Having said all that, in the purpose of this conversation, this conference, what we're looking at is the quantum of damages. So notwithstanding the interesting legal issues arising from the pension argument and various other arguments, the court found that the plaintiff had succeeded in proving negligence, and the plaintiff was entitled to an assessment of damages for various heads, including general damages, which were awarded in the amount of $230,000. Once again, this is a case coming out of South Australia, and I'm sure that we're all sort of understanding now that and appreciate now that the courts in different jurisdictions are making different levels of awards of damages based on the jurisdictions from which they arise. In this next case of Phillips and Amica, it's a case that was against, once again, the formerly James Hardy, heard in May 2019 before Her Honour Judge Strathty, who at that stage was a relatively new judge on the in the tribunal, but a very, very experienced barrister in the area of Dutch disease. Her Honour made findings in relation to the plaintiff's health. In this case, the plaintiff was found to be, by late 2018, was described as being in good health, particularly with a cardiac function, because there was some different medical records that talked about that. But by October, there was a noticeable spike in the plaintiff's, there was a sudden spike in the plaintiff's symptoms, an excruciating pain in the back of the neck and the right leg, and this was seen to be from cervical stenosis. There was, however, some investigations made for that to see if they could be treated, and the plaintiff's pain persisted. What occurred then was that the plaintiff, after some time with medical treatment, did get some relief from the pain, but it continued to persist and it was never completely cured. A few weeks after that, the plaintiff realised that he was suffering from shortness of breath. There was a bad cough and was coughing up sputum. That led to the admission at Sutherland Hospital on 5 December 2018, and there was a pleuroscopy undertaken and talc-pleurodesis with biopsy. In this case, there was a fair bit of evidence given in relation to the plaintiff's independence. It was stated that the plaintiff was very independent and very self-sufficient, and an energetic man who enjoyed dancing, very light on his feet, went for long walks up to 5 and 6 kilometres at least 3 times per week. He was dancing multiple times per week. He was very active. made the most out of life, and in fact, at 82 years of age, was still was 82 years of age at the time of judgment, and it was found that he was active and energetic up to the deterioration in symptoms. In those circumstances, the court found that an appropriate award for general damages was $350,000. So we're now seeing fairly awards for general damages, particularly in New South Wales, over 300,000, and really consistently in that mid $300,000 range. The next case on the list you'll see is Piatti. Piatti was an interesting case from a legal point of view in terms of technicalities relating to claiming loss of third-party services type damages, and there were some interesting arguments and determinations made in that respect. But for the purposes of this presentation, we're really confining our discussion to the assessment of damages. And this is one where Judge Russell again decided the matter. The plaintiff unfortunately had passed away by the time the judgment was handed down. He died on 22 April 2018 from mesothelioma. The court held that it was demonstrated that about 2 years of symptoms had been suffered by the plaintiff. And in this case, rather than epithelioid or other types of mesothelioma, it was found that the plaintiff suffered from sarcomatoid mesothelioma, which is a very often considered to be the most aggressive, one of the most aggressive forms of mesothelioma, and the pain was properly controlled. Just couldn't control the pain, and it became unbearable. In those circumstances, the court found that the appropriate award for general damages was $370,000. So again, we're seeing a rise in the GDs. This next case, once again, we're going back to South Australia for a short while. This case of Werfel, this case involved enormous and really substantial volumes of evidence in relation to technical legal arguments relating to in-situ exposure to asbestos. Mr. Werfel's case was interesting also medically because not only was he exposed relatively recently from about 1994 to about 1997, but he also had exposure in the early 20th century, 2001, 2005, from maintenance work undertaken in Adelaide. The other thing that's really interesting about this case is that he suffered from a very rare form of mesothelioma affecting the tunica vaginalis testis, which occurred in 2017. My understanding is that this type of mesothelioma affects less than 1% of the population, and it may even be, on a certain reading of it, less than 1% of those that suffer from mesothelioma in general. It's a very rare condition. But it was held that the condition was one that was caused by the defendant's products, causing mesothelioma down the body. And medically, the case was proven. Issues in relation to exposure and the issues surrounding duty of care and breach of duty of care were determined by the trial division, and they were held in the plaintiff's favour. The plaintiff succeeded, and the court found that the appropriate award for a man with this condition at the age of 42, so very, very young in this context, ought to be awarded $400,000 for general damages. That's $400,000. Unfortunately, the case was appealed, and the full court of the South Australian Supreme Court held that while the plaintiff still succeeded on the substantive points, the sum of general damages was excessive, was affected by error and manifestly excessive, and ought to be set aside. An award was substituted in the sum of $280,000, which still in the context of cases in South Australia is a not insignificant award of damages. Just for completeness, I'll mention that the Werfel decision was appealed again to the High Court, mainly on the issues of duty of care and breach of duty of care. And the High Court found that there was no no question of general principle that arises that ought to be assessed and determined by the High Court. And fortunately for the plaintiff, the special leave was refused with costs. In the next case, Williams, this is one from 2020, the DDT. Joe, if you could just turn to that next slide, please. This is one from, as I said, DDT. It's from 11th March 2020. I'll quickly run through these cases because we're running out of time. Mr. Williams' case was decided by Judge Scotting, 5 and 10 March 2020. This is a case for mesothelioma, and it's in fact one of the largest verdicts for general damages for mesothelioma in the DDT. The time of judgment, the plaintiff had 1 month to live, and his prognosis was given to be 12 to 18 months. He received an award of $385,000 in general damages. In this next case of Boland and Amica, the plaintiff's case was heard on 6 and 7 April 2020 before Judge Scotting. Plaintiff was born on 22 August 35 and was 84 years of age at the time of judgment. He suffered from ARPD, asbestos-related pleural disease, and it was found that he would die within 12 months from those conditions and complications of those conditions. Interestingly, in that case, it was a situation where Mr. Boland suffered from symptoms from about 1999. So he had pleural disease, suffered it for about 21 years leading up to judgment. The court actually found that he was so healthy and that no other conditions were affecting his symptoms but for the asbestos-related pleural disease and the asbestos disease in general. And all his symptoms that were worsening over that 2-decade period or thereabouts had been caused by the asbestos disease. And in circumstances where that was held, the court found that not only will that period be compensated for, but also clearly such a long line of symptoms and deterioration in symptoms of that trajectory will clearly continue into the future. And that was significant in the court finding that the appropriate award for general damages there was $350,000. Next case of Kennedy and CIMIC contractors. This is another case involving what was called choice of laws. It was before Judge Scotting in 2020. Again, DDT. The tribunal found that there was an assessment made against 2 defendants. One assessment was made for WA exposure, one assessment was made for New South Wales exposure. In respect of the exposure in Sydney, it was $350,000, and against the other defendant it was $430,000. And once again, it was a case where the plaintiff, could choose the assessment, but obviously without double dipping. The next case of Parkin. Parkin was one from WA, the Supreme Court of Western Australia. Judgment delivered on 27 August 2020. This is for mesothelioma. Liability was admitted. Just an assessment of damages. The plaintiff there was 63 years of age at the time of trial. She was very fit and healthy prior to trial, prior to being diagnosed with mesothelioma. She underwent various investigations. She held different jobs. There was an assessment in relation to, investigation and consideration in relation to a past history and a future history in relation to medical treatment that she would choose to undertake, including chemotherapy and immunotherapy, and how that would affect her moving forward. The appropriate reward there for general damages was $360,000, which is quite a substantial verdict for that type of case in Western Australia. The next case of Reid, just quickly moving through these last few. Reid was very relevant because it was one of the biggest or the biggest case for a judge to award general damages on. This is one out of Victoria. I did mention the case of King and Amica. This one was for Mr. Reid and Seltsam, 2021 Victorian Supreme Court. Plaintiff had mesothelioma. He was born on 27 October 51, generally in good health prior to the meso diagnosis. He was diagnosed on second biopsy, so he had a fair bit of investigation in terms of VATS procedures and talc-pleurodesis and various other medical investigations. He had 4 cycles of chemotherapy by the time of trial, and was too unwell to continue a 5th and 6th cycle. The tumour had in fact affected her thoracic spine, and the court considered the previous verdicts, including the matter of King, where there was the award I mentioned before of $730,000 in general damages. In this case, as a judge, the judge awarded general damages in the sum of $580,000, so quite a substantial verdict. The case then was appealed by the defendant, and thankfully for the plaintiff, the judge decided that it was not manifestly excessive, and the application for leave to appeal was refused. Just next slide, please, Joe. These last couple of slides, the last couple of cases I've included because they're really just psychiatric cases. In the DDT or other jurisdictions, we don't see many psychiatric cases for asbestos disease. So I've just listed 4. I've cherry-picked: Clayton, Crane, Dunning, and Londos. I'll quickly breeze through them. In Robert Clayton, plaintiff was employed in New South Wales. He developed various psychiatric conditions and respiratory symptoms, so he had both. He was 51 at the time of hearing. The court awarded $80,000. This is one from 2001, so talking 21 years ago. Next case of Crane against the Commonwealth, 2006. Plaintiff was exposed in the Royal Australian Navy, had asbestosis and pleural plaques. There's a lot of questions about his psychiatric condition, and it's probably too much to discuss in this presentation, but it's worth a read. There's a lot of evidence given about his the nature and extent of his psychiatric symptoms. Ultimately, an award was made for $100,000. Mr. Dunning's case, just a case from 2014, New South Wales DDT. This is a very substantial award for general damages from Mr. Dunning. He had very, very serious symptoms over many years from mesothelioma. The award of general damages there was $500,000, and he had, again, physical symptoms and also psychiatric symptoms. And the final case I've just cited there is Londos from New South Wales DDT. Once again, DDT case, 2017, and case for left side malignant pleural mesothelioma. Symptoms began in 2006. Mr. Londos was 79 years of age at the time of judgment, and the award of general damages there was $350,000. All right, well, I think I've just squeezed all that just in the 1 hour. So sorry about the rushed finish, but we managed to get through those slides. And if you have any questions, happy to answer them.
Thanks, Martin. Yeah, so over to you guys now. Those of you who are with us, if you had a question, you're welcome to pop it in the chat. If you don't want to open your microphone, otherwise just pop over your microphone and feel free to ask away. And also, Martin, of course, thank you so much. Just the depth of knowledge is obviously so amazing, and we're very lucky to have you present for us. So appreciate the presentation. That's great.
My pleasure. Thanks, Joe. No worries. As Joe said, if anyone's got any questions, feel free to just ask them via chat or just email them through, and we can answer them in due course.
Yep. I'll give it a few more seconds. Someone wants to pop in. Otherwise, of course, everyone should have our email address as well. So you can send through any questions that might come up later on, as I'm sure they often do. I'll give you a few more seconds now if you'd like to ask one. That usually means you probably covered everything.
Good news.
So look, maybe we'll wrap it up there. Thank you again for joining us today, Martin. I expect, no doubt, we'll have you on again in future if you'll have us.
Of course, that'd be great.
Yeah, and I might just stop my share screen there.
Thanks very much, Joe. Take care, guys.
Thank you. See you later.
Bye-bye.